Good afternoon, everyone. Thank you for the amazing turnout that our conference has had so far. Thank you all for being here. I'm honored to be the moderator of today's last panel that will talk about such an important issue as environmental law. In this panel, we will discuss the role of litigation and legislation in addressing climate change in Brazil and in the US. And to discuss on this important topic, I would like to introduce you to our panelists. So our first panel member is Judge Gabriel Vedi. He's a federal judge in Brazil, and he's also an environmental law professor at the Unicinos University and also at ESFAME in Rio Grande do Sul. He also holds a PhD and a master's degree in environmental law from Pontifícia Universidade Católica do Rio Grande do Sul, and also a visiting scholar at Columbia Law School. He was also the president of the Federal Judges Brazil Association between 2010 and 2012. Our second panelist is Professor Michael Girard. He's an Andrew Sabin Professor of Professional Practice at Columbia Law School, where he teaches courses on environmental law, climate change law, and energy regulation. He's also the director of the Sabin Center of Climate Change Law in Columbia Law School, and he chairs the faculty of Columbia University's Earth Institute. In terms of panel dynamics, I'll ask each of our panelists to give their individual presentations for about 20 minutes, and then we'll open the floor for audience questions. And for that, I remember you to please submit your questions through the Slido app by using the hashtag Harvard Law Brazil. So let's kick off with our first panelist, Gabriel Vedi.
Good afternoon. My name is Gabriel Vedi. I'm a federal judge, an environmental law professor in Brazil. It's a great honor to have been invited to give this presentation here at Harvard Law School. Many thanks to this great university, to the Brazil Harvard Law School Students Association, Isabella and Eric, and the Rio de Janeiro and Espírito Santo Federal Judges Association, President Fabrício Castro, my dear friend, Professor Michael Girard, my friend, professors, colleagues, and students. My talk is about legislation and climate litigation in Brazil. Brazil plays a major part in the global fight against climate change, especially because of its vast forests. However, the amount of deforestation now occurring is in great disputes. Between August 2014 and July 2015, for example, deforestation in Brazil Amazon rainforest increased by 215%, according to Amazon Research Institute. In contrast, according to the Brazilian government, the increase was only 16%. Legislation and litigation should play roles in the present and in the future in combating deforestation and other factors relevant to climate change in Brazil. Brazil has a specific act on climate change. However, it needs to be enforced and interpreted in accordance with the constitutional principle of sustainable development, so as to be effective. The principle of sustainable development is provided for by Act 1287, which established the National Policy for Climate Change, NPCC. The Act, although imperfect and lacking in some respects, is a breakthrough and a milestone in the fight against climate change and global warming. It has clearly incorporated concepts of international instruments that protect the environment. The Act 12187 is implemented by Executive Order 7390, 2010, which, among other important points, states that the greenhouse gas emissions should be reduced from 36.1% to 38.9%. By the year 2020, however, before the United Nations Conference on the 2030 Sustainable Development Agenda held in New York in September 2015, Brazil promised that the reduction would be 37% by 2025 and 43% by 2030, exceeding the goals established in the executive order. The big question is whether Brazil will have the structure, technical capacity, and political will to seriously achieve these goals. The shortage of structure to monitor sources that emit greenhouse gases, the increasing deforestation of the Amazon rainforest, transport dependent on fossil fuels, the lack of environmental education in schools, and corruption are all serious obstacles to be fought against so that this goal can be achieved. The Act provides the principles, goals, guidelines, and the instruments of NPCC in Article 1. Important technical concepts were created for the Brazilian law, such as the concepts of adaptation, of adverse effects of climate change, of emission sources, of greenhouse gases, of impacts, of mitigation, of climate change, of GHG sink, and of vulnerability in Article 2. These technical definitions needed to be clearly spelled out and translated into legal language, since they must be employed with the greatest possible care and accuracy in the formulation and implementation of public policy, as well as judicial and administrative decisions. Among other things, the Act provides that economic and social development must be compatible with the protection of the climate system in Article 4. The relationships of the environment to the economy must always be considered when planning and implementing reductions of carbon emissions. The Act provides for tools including the National Plan on Climate Change, the National Fund on Climate Change, and, in particular, the assessment of environmental impacts on the microclimate and the macroclimate according to Article 6 among the institutional instruments for the work of the National Climate Change Policy are the Interministerial Committee on Climate Change, the Brazilian Research Network on Climate Change, and the Coordination Committee of Activities in Meteorology, Climatology, and Hydrology. Significantly, according to Article 8, provides that official financial institutions will make available credit and financing lines in order to produce and encourage clean energy. Principles, goals, guidelines, public policies, and government programs must be compatible with the principal objectives, guidelines, and instruments of the national policy for climate change. Consistent with the Article 10, the Act provides that the executive order, in accordance with the national policy for climate change, must set sectoral plans for the mitigation and adaptation to climate change in order to create a low-carbon economy. In order to create a low-carbon economy in the generation and the distribution of electricity, in urban public transportation, in the interstate transportation systems of cargo and passenger, in the durable consumer goods, manufacturing industry and chemical industries, in the pulp and the paper industry, in the mining, in the construction industry, in the health service, and in agriculture. The goal is to meet gradual emission reduction targets considering the peculiarities of each sector. Climate change litigation has been occurring in the United States for years, and is now common, but in Brazil it is very recent and rare. This is particularly due to the fact that there is not a sound doctrine regarding the climate change law in the country. The jurisprudence presents few interesting cases. I will talk about 3 cases in this presentation. This case that have already been judged by Superior Court of Justice. This case related to the anthropogenic factors causing climate change, and some mention their sometimes catastrophic effects. The Superior Court of Justice headquartered in Brasilia, according to the Articles 104 and Article 105 of the Brazilian Constitution. It is competent to judge in a special appeal the case decided in sole or last instance by regional federal courts, or by the courts of the states or federal districts, when the decision under Appeal 1 goes against treaty or federal law or denies its effectiveness. 2, judged as valid an act by local government contested due to a federal law. 3, construes a federal law differently from other courts. This court reviews cases related to environmental law when non-constitutional rules are being debated. The Superior Court of Justice has adopted a progressive jurisprudence regarding the protection of the environment as an independent legal asset and fostering sustainable development. This can be clearly seen in several situations. Pursuant to these comments, we will talk about this case judged by Superior Court of Justice that are relevant in fighting the anthropogenic factors causing climate change. The Superior Court of Justice, based on Article 27, the Old Forest Code, ruled in favor of the State Prosecutor Office of the State of São Paulo against the farmers Felipe Salles Oliveira and others, and found that it is illegal to use the technique of burning in the harvest of sugarcane due to its negative impacts on the environment and the emissions of CO2, contributing to global warming, in addition to causing respiratory damage to people, especially to farm workers. This decision came to the opposite conclusion than the later decision from the Supreme Federal Court in the case of the State of São Paulo and others versus the city and the City Council of Paulínia. In the decision of Superior Court of Justice, it was stated that academic studies show that the burning of sugarcane straw causes significant environmental damage, and that, considering sustainable development, there are modern instruments and technologies that are able to replace the burning practice without making the economy activity unfeasible. The court clarified that the exception of the sole paragraph of the Article 27 of the Old Forest Code to the prohibition of fires must be construed restrictively when it's authorized the fires for agro-industrial or agricultural activities, as the economic interests cannot prevail over the environmental protection, when there are techniques less harmful to the nature. According to Justice Martins, said Justice, the interpretation of the rules that protect the environment do not comprise only and solely the use of strict legal instruments, as it is a fact that the sciences related to the study of the soil, to the study of life, to the study of chemistry, to the study of physics, must help the jurist in his/her daily activity of understanding the fact that is harmful to environmental law. The cane field absorbs and incorporates CO2 in large amounts through its growing period, which lasts from 12 to 18 months on average. And the burning releases it almost instantly. In other words, in the period of one fire, which lasts approximately from 30 to 60 minutes. Therefore, the fire releases the CO2 collected from the atmosphere during 12 to 18 months in a little longer than 30 or 60 minutes. In addition, other gases are formed and released in the atmosphere together with CO2. According to the justice, a study carried out by Paulista State University, which concluded that the polycyclic aromatic hydrocarbons released by the fire causes cancer, affecting the bodies of workers in cane fields who are exposed to the smoke. According to the justice, the appellants have shown that the procedure is archaic and obsolete by stating that it is a secular conduct, in other words, a method used in time of major technological limitations. Surely, today the progress of agro-industry enables a mitigation of environmental damage without compromising its economic feasibility. Therefore, according to the opinion, the activity must be developed with modern industrial instruments and technology to reduce the environmental impact and not using fires in cane fields for the harvest that contribute with climate change. The voting was unanimous, with Justice Antônio Benjamin, Campbell, Calmon, and Meira following the opinion of the reporting justice. I will talk about the second case, ruled by the Superior Court of Justice. Braulínio Basílio Maia Filho filed an ordinary proceeding against IBAMA, Brazilian Environmental Institute, aiming at revoking fine applied due to a fire in a pasture carried out in an area of 600 hectares. The federal judge ruled in favor of the plaintiff on the grounds that the legal instrument that justified the fine could not be applied in this case. After an appeal by IBAMA, the Regional Federal Court reversed the decision on the grounds that the penalties for violation of the environmental legislation have express legal provision inserted in the Article 14 of the Act 6938. And the Brazilian Environmental Institute has legal authority to enforce them. Braulínio Basílio Maia Filho, dissatisfied with the decision, appealed to the Superior Court of Justice, which decided that it is legal to apply a fine due to the burning of 600 hectares of pasture pursuant to the provision of the Act 6938. Justice Antônio Benjamin, in his opinion, which the other judges signed onto, explicitly mentioned the relation between the fires and the climate change. Justice Benjamin stated that the law provides for application of fine for non-compliance with the measures required to the preservation or correction or inconvenience and damage caused by degradation of the environmental quality. It is certain that the expression non-compliance includes acts of degradation not only by omission but also by action. In this case, the appellant's conducts of carrying out the burning of an area corresponding to 600 hectares without authorization from the environmental agency violates the law. The fires are incompatible with the purposes of environmental protection established in the federal constitution and in the environmental laws. In times of climate change, any exceptions to this general prohibition, in addition to being expressly provided for in federal law, must be restrictively construed by the manager and the judge. The Superior Court of Justice, with this foundation, understood as legal the fine applied by IBAMA to Braulínio Basílio Maia Filho, due to carrying out fires in 600 hectares of pasture. I will review the third and the last case ruled by the Superior Court of Justice. The Federal Public Prosecutor Office of Joinville, Santa Catarina, filed a public civil proceeding against H. Carlos Schneider Company and SER, Parafuso, a labor entity congregating the employees of Caesar Group in Santa Catarina State. The Federal Public Prosecutor Office claimed that the defendants filed and drained a mangrove forest in an urban property, even after being notified by EBDF and FATMA environmental bodies, by the City Council of the City of Joinville and by the Port Authority. Federal Judge Moraes, our colleague, my colleague, condemned the defendants to removing the landfill and any buildings that are on the mangrove forest and specific reforestation of the mangrove forest. The decision by Judge Moraes was confirmed by the regional federal courts of the 4th region. The defendants appealed to the Superior Court of Justice. The Superior Court of Justice rejected the defendants' appeal and upheld the original decision favorable to environmental protection. In his opinion, which the other judges signed on to, Justice Antônio Benjamin, again, mentioning the risks of climate change, especially increasing sea levels, stated in the opinion. Stated Justice Antônio Benjamin, as a result of the evolution of scientific knowledge and change in the ethical attitude of the human being towards nature, several functions are recognized in mangrove forests. One, ecological, as a sea nursery, a core piece in the reproductive process of a large number of species. A biological filter that retains nutrients, sediments, and even pollutants, a buffer zone against storm, and a barrier against the erosion of the coast. Two, economic, source of food and traditional activities, such as artisanal fishing. Three, social, vital environment for traditional population whose survival depends on this exploitation of existing crustaceans, molluscs, and fishes. Current Brazil legislation reflects the scientific, ethical, political, and legal transformation that repositioned the mangrove forests, taking them from a condition of health risks and undesirable condition to the level of a critically threatened ecosystem, aiming at protection its ecological, economic, and social functions. The legislation assigned then a legal nature of permanent preservation. Area. Accordingly, it is everyone's duty, honors or not, to ensure the preservation of mangrove forests and ever increasing need, especially in times of climate change and increasing sea levels, destroying them for direct economic use with the permanent incentive of easy profit, and short-term benefits draining them or land, filling them for a real estate speculation, or soil exploitation, or turning them into garbage dumps, constitute serious harm to the ecologically balanced environment and to the welfare of the collectivity, a behavior that must be promptly and vigorously repressed and sanctioned by the administration and the judiciary. Concluding his opinion, the Justice Benjamin stated that it is unacceptable after the Federal Constitution of 1988, which valued the preservation of fundamental ecological process, and full non-compliance with the Forest Code of 1965, intending to give the mangrove forests other destination that is inconsistent with the untouchability assigned to it by law as a permanent preservation area. The decision of the Superior Court of Justice was unanimous in the sense of condemning the defendants to remove the landfill and any buildings that are on the mangrove forests and to make a specific reforestation of the mangrove forest. Justice Calmon, Noronha, Meira, and Martins have also participated in the decision and following the opinion of the Justice Antonio Benjamin. In conclusion, the decisions of the Superior Court of Justice in this scenario are according to the provisions of the Paris Agreement and the national policy of climate change. It is important that the Brazilian judiciary branch take the several threats posed by climate change seriously, such as droughts, floods, increased storms, rising sea levels, and environmental, social, and economic losses deriving from these facts. The Brazilian Constitution, the national policy of climate change, and the Paris Agreement are important instruments for legal decisions favorable to the environment and to the stabilization of climate for the benefits of present and future generation. Thank you.
Thank you, Judge Veggie, for this enlightening lecture. We'll now turn to Professor Michael Girard for his presentation.
Yes. Thank you very much. It is a great honor to be here this afternoon with all of you at this great university. I'm going to be talking about climate change litigation in the United States and also some of the most important climate change cases in other countries in the world. There is a very large volume of climate litigation in the United States. Our center at Columbia Law School keeps track of all of them. And as you can see, there have been, as of about a year ago, 654 lawsuits filed in US courts on climate change, far more than all of the other countries in the world combined. Australia is a very distant second. And there are also several countries that only have one or two cases. The kind of litigation that takes place varies a great deal with who is president of the United States. US climate litigation really began around 2001 when George W. Bush was president. Under President George W. Bush and Vice President Dick Cheney, the US government did almost nothing about climate change. Many lawsuits were filed by environmental organizations and by states that favored action on the environment. leading most importantly to a decision by the US Supreme Court in 2007, a case called Massachusetts versus Environmental Protection Agency, finding that the Clean Air Act of 1970 gives the Environmental Protection Agency the authority to regulate greenhouse gases. When President Obama took office in 2009, he reversed the US policy and began acting very vigorously on climate change. When that happened, the nature of US climate litigation changed completely, and the Obama administration was challenged in court by industry and by the states that oppose action on climate change. Then in 2017, when Donald Trump took office, the nature of the litigation again reversed, and now we have litigation brought again by environmental groups and states that favor climate action. So the amount of litigation has been going up, but the nature of the litigation and the identity of the parties has changed very significantly. When we add up all of the cases and look at what are the most important, the most common theories that were used, the largest number of cases are brought under the National Environmental Policy Act, which is the US law requiring environmental impact assessment. And also many states have similar laws, and so many actions under the state laws, primarily California. A lot of lawsuits brought under the Clean Air Act and under many other theories. So the lawyers have been very imaginative in coming up with new theories to bring these lawsuits. Today, most of the US climate litigation falls into these categories. Basically, every action that the Obama administration took on climate change was challenged in court by industry and by states. Some of those lawsuits are continuing. The most important of those concern the Clean Power Plan. That was the plan of the Obama administration to reduce the use of coal to generate electricity. After that plan was released, it was challenged in court, and the US Supreme Court issued a ruling staying the plan, saying the plan could not be implemented until all the litigation was finished. So that continues, but President Trump has started the process to repeal the Clean Power Plan, so that is no longer so active. President Trump is taking many actions to try to repeal the US environmental regulations, and the administrator of the Environmental Protection Agency, Scott Pruitt, is following through on that. Our center at Columbia Law School, on the day that President Trump was inaugurated, launched a website which we call the Climate Deregulation Tracker to keep track of all of these actions being taken by the Trump administration to stop the climate regulations. Almost everything almost all of these actions by the Trump administration are being challenged in court. Environmental groups and states are suing, and they have won several of those lawsuits, mostly on administrative procedure grounds, mostly because it was necessary for the government to have gone through a formal process under the US Administrative Procedure Act for public notice and comment, and the administration did not do that. But they will then go back and fix it so that they can continue with those actions. Another category of lawsuits is attempts to sue fossil fuel companies primarily oil and gas companies for money damages due to the negative effects of climate change. There were several of these lawsuits brought more than 10 years ago. One of them went up to the Supreme Court. The state of Connecticut and several other states sued several electric power companies, saying that their air pollution, their greenhouse gases were causing damage. And they asked the federal court to issue an injunction to require the power companies to reduce their emissions. The Supreme Court rejected that on the grounds that when Congress enacted the Clean Air Act, it gave the Environmental Protection Agency the sole power to regulate greenhouse gases, and therefore the federal courts should not be making their own rules. That was an injunction action, but the same theory was followed in a case called the native village of Kivalina versus ExxonMobil. This was a village in Alaska that is eroding away because their ice is melting. They wanted money damages from Exxon and other fossil fuel companies, and the court rejected that under the same theory that the federal courts may not do that. However, the Supreme Court left open the question of whether state common law and state courts may do that. In the last year, we have seen a total of 10 lawsuits filed using that theory. The slide says 9, but lawsuit number 10 was filed yesterday. So several cities and counties in California and the city of New York, and yesterday the city of Boulder, Colorado, have filed lawsuits in state courts against oil and gas companies seeking money damages from them because of the impacts of climate change. There are many questions about whether these lawsuits will succeed, but it's very interesting litigation to watch while it is happening. Another very interesting set of cases in the U.S. is brought under the public trust doctrine, the old doctrine based on Roman law that the government has an obligation to preserve certain lands and waters in trust for the public. Usually that doctrine has applied only to certain waters and so forth. But some professors in the U.S. have the theory that the public trust doctrine also applies to the atmosphere, and that the government has an obligation to protect the atmosphere from climate change. So a group called Our Children's Trust formed, and it has brought many lawsuits. Most of them have been dismissed, but one of them has had a great deal of success. That case is called Juliana versus the United States. It was brought by many young people, and their theory is that their generation is harmed by these greenhouse gas emissions, which will cause them, when they are older, to suffer. So in this lawsuit, the plaintiffs, these young people, are asking the federal court to order the Trump administration to prepare and implement a plan to drastically reduce greenhouse gas emissions. The trial-level court, the U.S. District Court in Oregon, rejected the U.S. government's motion to dismiss. This was shortly before President Trump took office. They had sued the Obama administration. Before President Trump took office, the U.S. Department of Justice, the defendants, answered the complaint, and they admitted many things. They admitted that climate change is happening, that humans cause most of it, and that it's a real problem. When the Trump administration took office, they asked to appeal. In this kind of case, you cannot appeal as of right until the very end of the case. They were unable to pursue that appeal. The Court of Appeals rejected that. And just last week, the court scheduled a trial date for October 29. So we're going to see a very interesting trial in Oregon starting in October 29 on the issue of how much did the federal government know about the dangers of climate change and what duties does it have to reduce climate change. Again, I am not confident that this decision will ultimately be upheld by the Supreme Court, but it's very interesting to watch meanwhile. Another category of actions are investigations being done by the Attorney General of the state of New York and the Attorney General of the state of Massachusetts, where we are today, investigating Exxon Corporation. And this is based on securities disclosure. The issue is whether Exxon knew a great deal of information about the dangers of climate change, but did not disclose that in its filings and its disclosures to investors. And therefore, the question is Exxon guilty of securities fraud? So these are just investigations. No charges have been filed yet. But Exxon has brought several lawsuits against the Attorneys General of New York and Massachusetts to try to shut down the investigation. So far, all of those have failed. All of those challenges have been dismissed. And so these investigations are going forward. There are also efforts being made to argue that the fossil fuel companies should be liable in the same way that the tobacco companies were held liable years ago for failing to disclose the health impacts of smoking. So those are the most important kinds of U.S. litigation. I now want to talk about some of the most interesting litigation outside the U.S., and this is a report that our center prepared for the United Nations last year that talks about these cases. In the Netherlands, a non-governmental organization called the Urgenda Foundation, Urgenda for urgent, sued the Kingdom of the Netherlands, saying that the government of the Netherlands should be required to reduce the country's greenhouse gas emissions under the duty of care that is part of the law of the Netherlands. The plaintiffs won. The trial court issued an order to the national government to reduce its greenhouse gas emissions. This decision is now under appeal to the Intermediate Appellate Court in the Netherlands, but meanwhile the government of the Netherlands is complying with the order and is taking steps to reduce national greenhouse gas emissions. In Pakistan, a farmer in Pakistan sued the government, saying that the government had a national plan to adapt to climate change, to help people prepare for the impacts of climate change. The trial court in Lahore, Pakistan, ruled in favor of the farmer and the judge set up a commission of experts and officials to come up with a stronger plan to prepare for climate change. And that commission is now at work. In Colombia, just about 2 weeks ago, the Supreme Court of Colombia issued a ruling that the Constitution of Colombia requires protection of the forests. And it ordered the national government to take steps to protect the forests of Colombia. partly to protect against climate change. A lawsuit has been brought in Germany by this fellow who is from Peru. And this plaintiff lives near, is also a farmer in Peru. He lives near a glacier that is melting. He is alleging that the glacier is melting because of greenhouse gases. And he is suing RWE, which is the largest electric power company in Brazil, saying that RWE caused 0.5% of the greenhouse gases in the atmosphere, and therefore RWE should pay him 0.5% of the damages that he is suffering as a result of the melting of his glaciers. This was brought in a trial court in Germany. The court initially, the trial court rejected the lawsuit, but the appellate court reversed and said the lawsuit may go forward. And so this lawsuit seeking money damages against the German electric utility company is moving forward. And finally, the Human Rights Commission in the Philippines has started an investigation that was first requested by Greenpeace into the responsibility of the fossil fuel companies for climate change in the Philippines. The Human Rights Commission has held hearings in the Philippines. None of the fossil fuel companies appeared. They argue that this commission does not have jurisdiction over this case. But the commission is going to have hearings in New York and London as well to bring forth evidence about the amount of emissions of greenhouse gases caused by the production of oil and gas and coal. The Philippine Human Rights Commission does not have any power except to make recommendations to the national government of the Philippines. But I think that this case is going to attract a great deal of attention as they move forward with these hearings. So there are many other lawsuits that are being brought around the world on climate change, an increasing number of them. Almost every week we see a new lawsuit being brought. The environmental community around the world is very distressed that there has been too little government action on climate change, and so they are coming up with a wide variety of legal theories to try to ask the courts to take action. So far, they have persuaded the courts in Oregon and in the Netherlands and in Pakistan to take action, and they are moving forward with lawsuits in several other countries. Thank you.
Thank you, Professor Girard, for this enlightening lecture as well. Our panelists unfortunately have time constraints, so I think we'll only have time for one question from the audience. And the question is, I think both of you can answer it, and is why do you think environmental regulation is not treated as seriously in Brazil, where environmental resources is so vast?
Well, you'll have to answer that.
I will answer in Portuguese because the audience is Brazilian. No Brasil nós temos, na verdade, leis ambientais altamente modernas. Nós temos a Lei 6938 de 81, né? Temos a Lei da Política Nacional da Mudança do Clima, e essa jurisprudência extremamente progressista do Superior Tribunal de Justiça, que reconhece a imprescritibilidade da ação de reparação de dano ambiental, reconhece a responsabilidade por ação e por omissão do Estado em casos de danos ambientais. Então, nós temos uma jurisprudência extremamente progressista, uma boa legislação, e, ao contrário dos Estados Unidos, a Constituição brasileira protege o meio ambiente por ele mesmo. Nos Estados Unidos, para se ter um caso, para se ter uma ação ambiental, é necessário que haja a violação de um direito individual. Né? Você precisa ser reconhecido um standing, né? Para que se possa proteger o meio ambiente de um modo indireto. Né? Uma situação parecida com o que nós chamamos de dano ambiental ricochete no Brasil. Né? O dano ambiental ricochete, o que acontece muito quando existe poluição de rios, poluição de lagos, por exemplo, que ocorre um dano à flora, um dano à fauna, né? Mas também um dano econômico aos pescadores, às pessoas que fazem turismo local. Né? Então, eu acho que o direito brasileiro está bem regulado. O que falta no direito brasileiro para combater as mudanças climáticas é o que o professor Michael Girard defende, inclusive de modo combinado, que é a criação do mercado do cap and trade e também se colocar preço no carbono, né? A atuação combinada da precificação do carbono, né? Com a criação do imposto sobre o carbono, feito isso de modo combinado com o mercado, os mercados podem ajudar para proteger o meio ambiente. O cap and trade, existe cap and trade na China, por exemplo, existe no estado da Califórnia há tempo, né? Em algumas regiões dos Estados Unidos, existe no Canadá. O Canadá criou também a tributação sobre o carbono. Então, a aplicação combinada entre o carbon tax, né, e o cap and trade é o caminho. O Brasil precisa enfrentar isso dentro do Congresso, fazer um grande debate na sociedade, né, brasileira. E nós temos o grande problema do Brasil nas emissões de gases de efeito estufa, um pouco diferente dos Estados Unidos, que tem as maiores emissões, elas vêm, na realidade, dos combustíveis fósseis. No Brasil, ela vem do desmatamento, né, e também da agropecuária. Então, as fontes de emissão de gases de efeito estufa são diferentes, né? No Brasil e nos Estados Unidos, claro que nós temos um problema também de utilização excessiva de combustíveis fósseis, porque nós não temos trens elétricos, por exemplo, nós temos rodovias sucateadas, e os automóveis utilizam combustíveis fósseis, e nós estamos muito atrasados na questão do desenvolvimento e no incentivo fiscal à venda, produção e comércio de carros elétricos, o que já ocorre muito na Europa, né? Espanha, Portugal, os países europeus, todos se preparando para banir os automóveis movidos por combustíveis fósseis dentro de muito poucos anos, né? Então, nós temos que partir, e eu acho que o professor Girard, uma das autoridades mais importantes no mundo sobre o direito às mudanças climáticas, apanhou bem isso, né? O cap and trade e a tributação sobre o carbono aplicados de modo combinado podem ajudar ao combate às mudanças climáticas e também para que nós possamos, com seriedade, alcançar os objetivos que nós estamos comprometidos com o Acordo de Paris, né? Para que as temperaturas não aumentem mais de 2 graus Celsius e, preferencialmente, elas aumentem no máximo 1,5 graus Celsius, tentando chegar a 1,5 graus Celsius, tendo como marco inicial a época da pré-revolução industrial, ou seja, o ano de 1750. Então, vejo... Temos boas leis, temos a Constituição brasileira que defende o meio ambiente, temos bons precedentes, precisamos avançar, sim, legislativamente na criação da tributação do carbono e na criação do mercado do cap and trade no Brasil.
Thank you, Judge Vedi. With that, I would like to end our panel today and also our third day of the conference. Thank you all for being here. Thank you for our panelists. Thank you all.